Extending clients' business or protecting their intellectual property in Brazil can be an excellent opportunity. However, the Brazilian Patent and Trademark Office, known as INPI in Portuguese, has specific rules that often catch foreign attorneys and companies by surprise. These minor misunderstandings can cost thousands of dollars, cause years of delay, or even lead to a total loss of rights. In this video, we'll analyze the 3 most common mistakes foreign applicants make when entering in Brazil, and, more important, how you can avoid them. Mistake number 1 is regarding the specification trap. One of these mistakes is assuming that the Brazilian PTO analyzes the trademark specification the same way as other countries like US PTO or AUI PTO. In Brazil, the principle of specialty is applied much more strictly. Foreign companies, they often reduce broad and generic class headings. Then, what will happen next? The Brazilian PTO will issue automatically an office action regarding the clarification of this specification. Then your local attorney have to respond it within 60 days. If does not correct this exactly as the Brazilian examiner expects, the application is permanently dismissed. The solution here is simple. You have to adapt the specification to local practice before the filing, not after. This can reduce the time frame and also your money. The second mistake is missing the 90-day deadline for trademark priorities. This mistake involves claiming priority under the Paris Convention. Most international applicants know that they have 6 months to claim trademark priority. However, at the Brazilian PTO, if you fail to submit the official certified copy, either in a digital version or physically, of the priority document within 90 days from the filing date, you automatically lose your right of priority. There are no extensions. They will not send you any deadlines or any notice about it. This is a critical issue that frequently undermines the international filing strategies, leaving the trademark vulnerable to a local third-party competitor who might have filed the same trademark during this period. The third mistake is underestimating the Brazilian PTO office actions. Treating those office actions as mere bureaucratic requests that take a long time to process. The Brazilian system operates under a strict and often non-extendable 60 days deadline for responding to almost everything related to patents or to trademarks. Since the Brazilian PTO updates its official gazette weekly, if your local associate misses the notice or takes too long to notify you, half of your response time is already gone. So missing a deadline with the Brazilian PTO usually means having to start the entire process over from scratch, throwing away years of progress in the examination line. Navigating the intellectual property ecosystem in Brazil doesn't have to be risky if you count with the right local expertise. By tailoring your specification, close monitoring local deadlines, and working with a proactive associate, the Brazilian market becomes a high, secure environment for your portfolio. If you need any assistance related to that, or you'd like to understand better how the Brazilian PTO works with the backlogs or any specific intellectual property rules, subscribe to our channel. If you have any pending case or questions about IP assets in Brazil, contact our team via the link in the description. See you in the next video.